Hi everyone, my name is Naima Brandeyo and I am the Street Law Team Leader. This presentation will consist of my presenters doing their presentation on each part of defamation and then my team's legal researcher at the end with a scenario for all of you. Now let me introduce you to all of the team. Here you have DT, over here Sobia, and that's Victoria. I hope you enjoy the presentation, and if you have any questions or any comments to make, just let us know. Thank you.
Hi everyone, my name is Victoria Kiru and I'm going to be talking to you about a key element in defamation when establishing liability. So, when establishing liability for defamation, the material in question must be defamatory. According to the case of Sim versus Stretch, a statement is deemed to be defamatory if it lowers the judgment of right-thinking members of society have a view. To test this, the courts are going to apply a reasonable person's test as set in Lewis v. Daly. The statement must lower a person's reputation in the eyes of ordinary persons who are not overly suspicious or overly naive. Also someone who is not overly keen to scandal, where they may prefer defamatory meanings over non-defamatory ones. We must also differentiate defamation from abuse. It is not defamatory statements if they're mere insults at the heat of the moment. Furthermore, the Defamation Act of 2013 Section 1 places a requirement for seriousness. A statement is not defamatory unless it causes serious harm or is likely to cause serious harm. So for example, in Theodem v. Norwich, training emails were sent by a manager alleging improper conduct of employee. The courts deemed this to be potentially serious because the defendant was influential and it was sent to people in close proximity to the claimant. There are also true innuendos and false innuendos when looking at whether material is defamatory. A true innuendo is the meaning is apparent only to some readers who are aware of special facts. So for example, in Tolly v. Fry, it was implied that a player had endorsed the products. Now, if you had special information, you would know that this endorsement compromised the amateur golfer status of the player, therefore leading to a defamatory statement. A false innuendo, on the other hand, is where the literal words itself are not defamatory. However, a reasonable person can gather a defamatory meaning for it. So for example, there's no smoke without fire can be used to imply guilt. This was also ruled in Lewis v. Daly.
In order for a statement to be seen as defamatory, the second element of defamation must be established. This is if the statement referred to the claimant by his name. If the statement did not refer to the claimant by his name, then the statement cannot be seen as defamatory. So we can use a test to see whether or not the statement actually referred to the claimant. The test is, would the reasonable person with knowledge of special circumstances take the words as referring to the claimant? A case which can be used to illustrate this test is Hulton and Co versus Jones from the year 1910. This is where a barrister of the same name sued for defamation. There was an article about a person called Artemus Jones, and so everybody thought, including his friends, that the article had in fact referred to the barrister. Because his friends thought it had referred to him, it was held that the reasonable person would also assume that the article was referring to the barrister. It didn't matter that the defamation was in fact unintentional. Another case, which is the reasonable person test, is in the case of Newstead versus London Express from the year 1940. A newspaper truly reported that a Harold Newstead, aged 30 from Camberwell, had been convicted of bigamy. There was also another Harold Newstead in the area who was about the same age, and he successfully sued for defamation. This was because in the newspaper there was no description of the criminal Harold Newstead, and so people just assumed it was the innocent one. It was also held that the reasonable person would have thought the article was about the innocent Harold, and so therefore the innocent Harold was successful in his case of defamation. Group defamation cases are generally not recognised because we wouldn't be able to work out who the defamatory statement was actually about. There may, however, be a claim if the group referred to is so small that we can see the statement definitely referred to them.
The third part to establishing defamation is that it must be published. A publication refers to a statement that comes to the knowledge of a third party. This could be in a newspaper or online. If defamation is established using the three criteria that it must be a defamatory statement, it must refer to the claimant, and it must be published, then there could be a successful claim for defamation. There will be remedies available to compensate the claimant. There are two types of monetary damages available for the person who claims to have been defamed. These include general compensatory damages. This means that there was some financial loss suffered. It may be possible to claim for the compensatory damages, aiming to compensate for the damages to the reputation and taking account of the distress, hurt or humiliation caused by a defamatory statement. The second type of monetary damage available is the aggravated compensatory damage. These compensate the claimant when the defendant has acted in an improper or unjustified way, and it has increased the injury to the claimant's reputation or feelings. Examples of improper or unjustified actions include failing to check the truth of material before publishing it and refusing to apologise. As stated, the normal remedy for defamation is damages. However, in some cases, damages may not be an adequate remedy and therefore an injunction may be granted. An injunction grants that any similar publication that contains a defamatory statement about the party is not repeated in future publications. There could also be an opportunity to get a non-legal remedy. The remedies which a claimant is likely to be most interested in is obtaining an apology, a retraction of the statement, and possibly correcting the statement in a future publication. However, this apology or retraction of a statement may be given in private, it may be given in high court or in the public domain. All three avenues of remedies are available to the claimant.
Hi, my name is Abdul Tarwala and I am the legal researcher for the University of Leicester Street Law Pro Bono project. In this project, we're going to be discussing the law of defamation. Firstly, we look at the definition of defamation. We see that defamation refers to harming another person's reputation by making a false written or oral statement about that person to a third party. To better understand this, we will be looking at the recent case of Depp v. News Group Newspapers Limited. In this case, the famous actor Johnny Depp issued a libel claim against the Sun newspaper regarding an article published on the Sun's website. The article's headlines read, "Gone Potty, how can J.K. Rowling be genuinely happy casting wife-beater Johnny Depp in the new Fantastic Beasts film?" The libel claim was issued regarding the term wife-beater, which was related to Depp's former wife and famous actor Amber Heard. We must first see if Depp's libel claim fulfilled the conditions of a defamatory statement to be accepted in the courts. We see that the material itself was indeed defamatory and would possibly lower the claimant, Depp, in the eyes of right-thinking members of society. We then see that the material referred to the claimant as it mentioned him by name, Johnny Depp. Then we see that the defamatory statement was published on the Sun's website. Lastly, we consider the requirement of seriousness. Depp's legal team claimed the term wife-beater was untrue and would cause serious harm to Depp's personal and professional reputation. The judge in this case, Justice Nicol, including the defendant, the Sun, accepted that the term wife-beater would potentially do serious harm to his reputation. Now that the court accepted the statement to be defamatory, we look towards any potential defenses applicable to the defendant. There are a variety of potential defenses in the law of defamation, but the defense which the Sun's legal team used was that of truth. The Sun claimed the statement to be substantially true. Now, the burden of proof in the civil litigation claim was transferred from Depp having to prove the serious harm to his reputation to the Sun having to prove the statement to be true. On the balance of probabilities, the court accepted the statement to be true, as out of the 14 incidents of physical violence alleged against Amber Heard, 12 of them had been proved to the civil standard. Justice Nicol rejected Depp's case that the incidents were a hoax created by Amber Heard and found that she had not been physically violent towards Depp. For this reason, Depp lost his defamation claim against the Sun.